Good afternoon, everyone. So my name is Sister Donna McAllister. I'm here. This is our Family Life segment. And this week, we will be highlighting a Forever Young 50 Plus ministry. Last month, we had the privilege of introducing our ministry to you, and we have outlined some strategic goals. So today, we would be addressing one of those goals. The month of September, we have designated for financial wellness. Today, specifically, we have someone in our panel here today that will be presenting something very important to all of us in the area of finances. We will be discussing estate planning and gift planning as well. So I'd like for you to sit back, relax. We have Sister Valencia, who is our financial advisor as well, coming to us from Church of the Oranges. So at this time, I will hand over the mic to her, and she would introduce our special guests today. Thank you.
Thank you, Donna. Thank you for having me, and good afternoon, everyone. It's my pleasure, as usual, to serve in the capacity that I do. And without further ado, we have an hour to just talk about the topic at hand. We are going to be looking at estate planning and having a planned gifting discussion this afternoon. I couldn't do it myself without my colleague, Naomi Becker Collier, and she will correct me on the last name if I watch it a little bit. But Naomi is an estate attorney. She is a partner, but I won't give you too much of her just yet. I just want to talk a little bit, and then we're going to engage Naomi to tell us a bit more about herself, and she has a presentation for us. After the presentation, if she hasn't covered everything in total, we have a few questions we'll ask her, but I'm sure she'll do a wonderful job in her presentation that she has for us. Before I formally introduce her and talk to her about estate planning, one of the things as a community I want to just bring to our forefront is that we speak a lot about stewardship. We talk about, how to return our tithes and our offerings and giving, etc. But there is a phrase that I've learned a long time ago. It says, charity begins at home. And being that charity begins at home, I'm going to extend it to say stewardship begins at home. And part of stewardship is how we take care of ourselves and our family. And what kind of legacy are we leaving for our family? We would have worked hard and built over the years, but how are we going to leave that or pass that on to our family members? So I think it's going to be a wonderful discussion this afternoon. And there are two questions, simple questions that I want to ask you before before I encourage you to sit back, relax, and enjoy with us. Simple things as, do you have a will? We don't like to talk about wills sometimes, we know, but do you have that? Do you have a child that needs to be taken care of if something should happen? Do you have you decided who will make your decisions for you if you should happen to be ill? Will somebody be able to pay your bills if you're incapacitated? If you have answered no to any of those questions, this is your program this afternoon, and we welcome you to stay tuned and glean as much as you can, and we're here to answer your questions even post the discussion. Naomi, welcome. I'm so happy that you're here.
Oh, it's my pleasure. Thank you for having me. I'm really excited to be here. Welcome, everyone. Thank you, Donna, for having me participate in this presentation. So I'm excited. I think it's going to be a great conversation.
Awesome. So tell us something about you, Naomi. Tell us, I know you're an attorney, and everybody knows that you're a partner. Tell us about your firm and what you do.
Sure. So I'm a partner with Pashman Stein Wilder Hayden. We are probably what they call a mid-sized firm. I am based in Hackensack, New Jersey, but we have offices in Homedale and also an office in New York. I am part of our Trust and Estates and Elder Law group. So we are a large firm with a small Trust and Estates department, and that is my group. I've been there for 4 years now, but I've been practicing for 20 years. So this is all I've ever done, and it's definitely my passion. So I'm excited to talk about it with you today.
Awesome. Awesome. Thank you. Well, ladies and gentlemen, I'll just share a few things about Naomi. She just told you, but formally, she's a member of the Bergen County Bar Association. She's a member of the Women's Lawyers in Bergen County. She is part of the National Academy of Elder Law Attorneys. She does look at elder and disability law. Sometimes we don't speak about disability as much, but she does do that. She looks a lot at estate and lifetime planning, wealth of information, wealth of knowledge, and a very, very warm person to work with. I've had the privilege of having clients work with her, and the feedback is just fabulous. So again, Naomi, thank you.
Oh, it's my pleasure, Valencia. Thank you for inviting me. I really appreciate it.
Sure. I know your presentation, you're going to cover a few things, but I just wanted to share with you some of the questions that I would have received prior. And as you go through the presentation, you may cover some of these in it. And if not, we can talk about them at the end. So I have a question here that came in that says, what happens if you die without a will? What are the criteria for the government to claim your estate when you die? Once the government gets involved, can your next of kin still make a claim on your estate? What kind of debt gets written off when you die? So we have a number of questions. I'll start with those, and then towards the end we can visit some of the others.
Sounds good.
All right.
Okay. Well, let me see if I can't figure out how to share my screen. Okay. Can you see that?
Yes.
Excellent, because it's on a different screen than the one I'm looking at. Okay. So my goal today is really the presentation I have, and I know you have some questions about charitable giving, and we'll talk about that towards the end. But the presentation that I've put together is really a very high overview of what you should be thinking about when you're thinking about trust and estates planning. Towards the end of the presentation, there's a piece on elder law. I don't think I'm going to focus on that too much, but I'm happy to provide the presentation if you'd like to circulate it. It has some great information on there, but based on the questions that you've been getting, I think that the trust and estates piece will be really what we should be focusing on. Okay, so the items that I will address with you, and some of your questions will be addressed in there, and then I think maybe we go back to the ones that didn't quite get captured, but I'll try to work it in as we go along, is estate planning basics. What is an estate plan? What does it mean? What does it include? What should you be thinking about? Common mistakes and misconceptions with estate planning, because I'm sure, Valencia, in your practice that comes up quite a bit. So I always think it's helpful to kind of talk about the things that can happen if you don't do your estate planning properly. And like I said, there's a piece in here that covers the elder law piece, more so the planning for long-term care. And I can touch upon it briefly, but I think it's really not as much of the focus as the questions seem to indicate that you circulated. Okay, so what is an estate plan? An estate plan is essentially sitting down, thinking about and planning for, in a thoughtful way, what happens if I become disabled during my lifetime and what will happen when I pass away. The importance of an estate plan is that everybody has very specific wishes surrounding those topics. So it's important to be able to talk about it in a time when you're not in crisis mode, when you can have a thoughtful conversation and think about the what ifs and the God forbids, but when you're not, facing them, it's much easier, I find, to be able to have a meaningful conversation about it. Because you're in a place where you can participate, enables you to be part of that process, as opposed to if you were ill and you couldn't make those decisions. And we'll talk a little bit about what that looks like if it happens and you don't have the planning in place. But it does let you decide how you want your decisions to be made in the event of disability and upon your death. So those are really important things. I believe one of the questions was, and I get this a lot, do I need an estate plan? I have X number of dollars. Do I really need a will? And I'll tell you that in my experience, whether you have $50,000 or $50 million, you have wishes, you know, and you want to make sure that you're taken care of. You want to make sure your family's taken care of. So it's just my experience that it's better to put those wishes on paper so that nobody has to guess what they are. Okay. And of course, everybody, you know, the goal is generally to protect yourself during your lifetime and your family after you're gone so that your wishes can be fulfilled in the most meaningful way possible.
Right.
Okay. So an estate plan is really a collection of documents that are important to have in place during your lifetime. So once a person turns the age of 18, they're an adult and nobody can make decisions for them any longer because they're an adult. So frankly, I know we're talking to an older audience, but the truth of the matter is once you turn 18 and nobody can make decisions for you any longer, it really does become an important conversation. Sometimes we look at estate planning at different age groups. What does an 18-year-old kid going to college need versus a single person that just bought a home versus a couple that just got married. Now they've got grandchildren that they're planning to retire. So really, estate planning evolves as your life evolves. So I think that's an important thing to think about. And we're going to talk about the different documents that are generally spoken about when we're talking about basic estate planning. So your will, that document matters when you pass away. That dictates how your assets are going to be distributed, how your debts are going to be paid, who's going to be in charge of that to make sure that it happens. And then the documents that are important during your lifetime, the financial durable power of attorney, healthcare proxy directive, a healthcare proxy, and a healthcare directive. And sometimes when we're talking about estate planning, we're talking about trusts, and I'll touch upon that a little bit during our conversation. Okay, so I said before, the will only really matters after you've passed away, okay? And it's, really important. Very often we have assets, and I'm sure that you can appreciate this, Valencia, that have beneficiaries listed on them, or are jointly owned with a right of survivorship. So it's really important to understand, and this is usually the starting point of our conversation when we're talking about a will, is what is there? What are the assets? How are they owned? How are they titled? And how do they pass when you pass away? There are two types of assets you can own when you die: probate assets and non-probate assets. So probate assets are assets that pass pursuant to the terms of your will. They're assets you own individually in your name, not jointly with somebody else, and do not have a beneficiary designation on them. So probate assets pass pursuant to the terms of your will. Non-probate assets are assets, maybe you own a house jointly as husband and wife, and one of you passes away, then it will automatically pass to the survivor of the two of you if it's properly titled. Maybe you have life insurance and it has beneficiaries listed on it. That will pass outside of your estate. It's important to note a few things about that.
Right.
I can create the most comprehensive will possible, but if everything you own has a beneficiary designation on it, that will doesn't mean anything, right? Mm-hmm. So it's really important when you're going through the process of doing your estate plan to take a look at that, to really figure out how your assets pass so you can make sure that what you want to happen happens, right? Because frequently we try to protect assets under a will, and I'll get to that. But if you wanted to protect assets for a child maybe until they're 25 or 30, but everything goes outside of the estate, then you're not achieving the goal. So that's a really important part of the exercise. And I'm sure that you come across that a lot, Valencia.
Titling is very important, and the beneficiary, it does.
And to that end, I'd like to say, if you have a financial advisor and you have an accountant and you have an attorney, their job is to work for you, to protect you and make things work for you. So let them talk, right? You have a team of people around you that want to be able to help you, and they will be the most successful in helping you if they are working together. So I just think that's an important thing to note. It's hard to achieve a goal when you've got different people working on different things and nobody knows what anybody's doing. So that's just
You're
point.
correct, Naomi. We see that all the time.
It happens all the time, right?
We have to talk about it. Or you're titled in a certain way over here, but then you are counterproductive because the will says one thing, but your titling says something totally different, and we haven't spoken. So it's
Right.
critical.
Yeah, and the problem is that if one says one thing and one says the other thing, it doesn't matter what the will says. If the asset goes to sometimes we see you get a job when you're younger and you've appointed somebody as the beneficiary of your life insurance, and then 20 years later, I'm having a discussion with you about your assets, and they're like, oh my God, my mother was appointed as the beneficiary of that life insurance, and they've been married and they've got kids.
Exactly.
And it happens all the time. So it's an important piece of the process.
Yes.
It's important to note that as long as you have capacity, you can always revoke your will. You can always amend your will during your lifetime. So the best, I encourage people, there's no perfect answer. I think it's important to be really flexible when you're creating a will, because we're looking at a finite period of time. We have a set of circumstances in front of us now. But things will change 5 years from now, 10 years from now. So it is an evolving process. I always encourage people to pull out your will every 3 years, even if you don't call me, just look at it, make sure it makes sense. Like sometimes I see people, they did their will when they first got married and now they have grandkids and they've named people they can't even believe that they've named under the will. So it's important. Pull it out, look at it. Again, it's so much easier to address it when you're not in the face of some catastrophe. So I would, get into the habit of, it's just a part of what you have to do. So review it because it makes sense to review it. Assets, we talked about how assets can be distributed under your will. Sometimes, especially for younger beneficiaries, we might create trusts under a will that will help protect that asset, based on the age of the child. Valencia mentioned before, do you have a dependent that, requires your assistance? Perhaps you have a special needs dependent that requires benefits, but also requires some protection in a trust. There are multiple ways that we can structure inheritances under a will that will achieve goals with protection for those beneficiaries. We also sometimes create trusts for tax planning purposes. For instance, if you are trying to create, if you want to have the most tax advantageous distribution of assets, there's ways to do that under the will, especially with married couples. And I had a thought that just passed out of my head. Oh, especially in blended families where we have second marriages, that becomes really important because maybe the husband comes to the marriage with a couple of kids and the wife does. And, generally spouses want to take care of each other, but if they don't share children, they want to make sure that their lineal descendants are ultimately protected when both of the spouses are gone. So we deal with that a lot under the will. I mentioned before, you can appoint the executor of your will. You can appoint one person, two people, a fiduciary from like a corporation, a bank, depending on your circumstances. Not everybody has somebody in their family that they trust, or, maybe they're concerned about children fighting and think it would be easier to have somebody that's independent. So there's all different ways to creatively address those types of concerns. And also in the will, almost every will I've ever seen waives the bond for the person you've appointed to serve as executor. It's one of the benefits of doing a will, as opposed to, if you don't have a will, we'll talk about what that looks like. But the court requires you to post a bond, which is like insurance that you're not going to take the money and run away. It's another expense to the estate that could be avoided, and it's waived usually in a will. Okay. So what happens if you don't have a will? And I think that was your first question, right, Valencia?
Right.
So if you die without a will, the state statute in the state in which you are domiciled controls how your assets are distributed. The state doesn't take the money. The state says how your money has to be distributed. So when you die with a will, that's called a probate. The executor you've appointed takes the original will to the surrogate's court, and they probate the will and they administer your estate. When you die without a will, it's called an administration. So the rules are a little bit different. Because you haven't appointed someone, there is a priority under the statute as to who gets first dibs at qualifying as executor as administrator rather of your estate. Essentially, it's your spouse, then your kids. If you have 5 kids, which of the 5 kids is going to be? If they don't all agree, that could cause a problem. So there's a priority under the statute, so you don't have any control over who is the one that makes those decisions for your estate. And then the intestacy statute will dictate how your assets are distributed among your intestacy heirs. Okay, so depending on the circumstances would dictate how it might be, how those assets might be distributed. Generally, if you're married and you have children and all of the children are from the same marriage, the assets will pass to the surviving spouse. It's what most people want. But if there is tax planning to be done, you're not doing any tax planning if you don't have a will. It's just it goes to them, and if you could have saved taxes, you're out of luck. If it is a second marriage like we talked about before, and there are children from the first marriage, the spouse doesn't get everything. It's kind of it's a calculation based on, a maximum of this amount and then a certain percentage over that. If you don't have, if it goes down to your children, because you're not married, it would be divided equally among your children, or if one of them predeceased, his or her share would go down to his children. But there's no trust planning, so there's no real protection there. Everything is distributed outright. If you have a child with special needs that is inheriting money from an intestate estate, once they have over $2,000, if they're receiving benefits, they lose their benefits. So it could be catastrophic. So it's kind of a big deal. You don't get to decide how things get done. Your wishes and your family dynamics don't get, worked into a plan that makes sense for your family. But at the end of the day, the state doesn't take the money. They just tell you what you have to do with the money. If that makes sense.
And it's so funny that, a lot of people talk about having a choice in what they do, but you have choice where you're living, but you have left, after you worked so hard, you have now left the state to make that choice for you.
Correct.
Doesn't seem too smart. So that, one of the reasons why we say to people, make sure you are planning and you are making that choice on your own.
Right.
And not leaving it to the state to make that decision for you.
Yeah, I agree with that. And it's, there's no creativity in intestacy estate. There's nothing that you can do to address those concerns that you might have had. It just kind of is what it is. And hopefully it won't create a problem. If you don't have children, you're not married, it goes up to your parents, for instance, and if they're not alive, it goes down to siblings. If you don't have siblings, they'll keep going out in your family tree until they find somebody. It could be somebody you don't even know, somebody you don't like. Frequently when we have situations where, maybe people are, you want to benefit your partner, but you're not married, and now all of a sudden you've passed away, that partner has no rights.
Right.
So there's a lot of different considerations. It's, it's very cookie cutter.
And it's
the
expensive.
intestacy statute. It can be. One of the things that New Jersey does pretty well is probate. Their probate court. It's not like New York is a little harder. It's a more intense process. In New Jersey, under normal circumstances, COVID notwithstanding, it's a pretty simple process to get it started. But the truth of the matter is, if you could have done tax planning, you're not doing it now. There's no flexibility built in. It is what it is. So I'd say sometimes you might achieve the goal, but it might not be as streamlined.
Right.
Okay. So a power of attorney is another really important document, regardless of your age, once you turn 18. And I talk to parents with kids going off to college all the time about this. You might be paying for your kids' education and sending them to college, but at the end of the day, the college they can't talk to you.
Right.
You have no authority to speak to them. So we talk frequently when parents are sending their kids to college about maybe putting in place simple powers of attorney and healthcare proxies, which we're going to talk about next, to be able to continue, because even though they're 18 and they're adults, they're still parenting them, and they still want to be able to help them, still want to be able to transfer money from their account if they need it at school, whatever the case might be, or God forbid there's a medical emergency. So really, it starts at 18, these documents, because if you haven't given somebody the authority, technically they're not supposed to do anything for you. Right. So the power of attorney allows you to appoint somebody to help you with your finances during your lifetime. When you pass away, the document is no good. You're not supposed to be acting under a power of attorney after the person has died. There are two different types of powers of attorney: a springing power of attorney and an immediate power of attorney. A immediate power of attorney is what it sounds like. As soon as you sign it, it's good. They can use the document to help you. Frankly, they could use the document to hurt you. But like the will, it's revocable. So if there are issues, you can always revoke it as long as you have the capacity. But there's another type of power of attorney called a springing power of attorney, which essentially springs into action when you need it. So if you would say essentially, when I become disabled, my power of attorney will now take effect. The problem with that is usually when you need the power of attorney, there's a lot going on. And it's a lot to be somebody's power of attorney. It's just a lot. So when you put that barrier up, it makes it difficult for the person that's trying to help you. And generally speaking, we're not trying to make things more difficult. So I frequently talk to my clients about the fact that it's really imperative that you trust the person that you're giving the power of attorney to. In my 20 years of practice, I've done one springing power of attorney. So I don't see them a lot.
Right.
But, again, we talk about trust, and frankly, if you have concerns that person might misuse the document, then maybe we need to be talking about appointing someone else.
Mm-hmm.
So, and powers of attorney can be general, meaning very broad. I can do what you can do, financially, pay my bills, pay my taxes, register my car, sell my house. Those are very basic powers given under a power of attorney. Or limited. Sometimes we see limited powers of attorney. For instance, if we are selling a house and we want somebody to be able to sign the closing documents for us, it's limited to that transaction. And pretty much anything you can do, they can do for you. Okay. Right. A general power of attorney should be durable, which is a fancy way of saying there should be a sentence that says, if I become incapacitated, this power of attorney is still good. Without it, when we all really need the power of attorney, then we've got a problem. And talk a little bit about what that looks like. You usually want to consider who you want to appoint to act on your behalf for financial decisions. You can appoint people to act jointly, to have a system of checks and balances in there. Frequently, spouses appoint each other first. If they have older children, they might appoint them as backups, trusted friends, advisors. But you want to have some backups built in case there's a problem, in case somebody just can't act. So it's just smart to have some succession. You might want to think about ages when you're appointing people. Like if you appointed somebody that's a little bit older, you might want to have a backup that's a little bit younger in case something happens. Because again, frequently we put these documents in place and we don't look at them for a long time. So things can change. So it just makes sense to have some flexibility in there. So I don't know if you can hear my son in the background.
That's okay. Happens.
Yes, slamming the door.
I
edit that out.
That the power of attorney is not valid for healthcare decision making. I know we're going to talk about health proxy.
We are, but you're right. It's not valid. It's solely for financial decision.
Right.
Financial decisions. That's what I wanted to say. The one power that you should be really specific about in a power of attorney is if you want your agent to have the authority to make gifts on your behalf. And sometimes we make gifts for tax planning purposes. Sometimes we make gifts to a religious institution on a regular basis. And without that authority, your agent cannot continue your pattern of giving. So it's important. Frequently, we don't want, it's a very powerful power. So you don't want to be very open-ended, you can give gifts to the mailman. We don't want you to give gifts to the mailman, but, frequently people are comfortable allowing their agent to make gifts to their spouse, their descendants, any charitable organizations that they support on an ongoing basis, because without it, if you become incapacitated, you might not be able to continue your charitable giving.
Right.
So that's an important point to think about. So you mentioned healthcare decisions. Much like the power of attorney, you should have a healthcare proxy in place. And the healthcare proxy is like a power of attorney, but for healthcare decisions. It allows you to appoint who you would want to speak on your behalf if you couldn't make medical decisions for yourself. I don't recommend appointing two people together. Sometimes we do it in the financial power of attorney because people are more comfortable with the checks and balance in place. Generally don't want people fighting over your healthcare decisions if there's an emergency. So you usually want to have one person that's going to be the person to speak to the doctors. And frankly, doctors don't want to have to deal with 3 co-agents for healthcare decisions. But much like the power of attorney, you want to have some backups. And if the first one is not available because they're traveling or they're no longer alive, it immediately goes down to the next one. And sometimes we will include language that encourages the agents to consult with the other agents if the circumstances permit, because the truth of the matter is families talk to each other when there's medical crises. Right. And if you want, if you've appointed one child because they're the oldest or have the most medical background, or you're the most confident in their, that they'll follow your wishes, but you want them to talk to their brothers and sisters, assuming there's time to do that, we encourage them to do that. Also revocable during your lifetime, as long as you have capacity to do so, and it expires upon your death. I should mention that both the healthcare proxy and the durable power of attorney should have HIPAA authorization language in it. So you've appointed people to speak and to transact on your behalf, possibly with medical professionals, certainly with healthcare proxy with medical professionals. So without a HIPAA release, technically they shouldn't talk to you. So you want to make sure that your power of attorney and your healthcare proxy have HIPAA release language in it for that purpose.
I have a question there for you, Naomi.
Sure.
I realize that a lot of practitioners now have a HIPAA release form when you go to the doctor to say who they should speak to.
Correct.
Again, as long as it doesn't contradict what they have, and then your proxy has something else,
right.
So it's so important that when we're doing our documents that they are aligned. So you're not putting.
I think it's important. And we'll talk a little bit about, we prepare just in the normal course of doing an estate plan, even though those two documents have specific reference to the HIPAA authorization language. Sometimes all you need is a general HIPAA release. So we will prepare a separate, very simple HIPAA release. And what that also allows you to do, it allows you, maybe there's somebody that you don't necessarily want making medical decisions on your behalf, but if you were in the if you were in the hospital, they might be the person likely to be there with you. If you wanted them to be able to speak to the doctor, it gives you an opportunity to add them to a HIPAA release, but not give them decision-making authority. So that's also something to think about, because you can authorize the release of medical information, but if you had that general HIPAA, it wouldn't matter what you said on that form for the doctor, because the general HIPAA would also control. Okay. So the healthcare directive works hand in hand with the healthcare proxy. It's essentially the document that tells the proxy you've appointed how you want those medical decisions to be made if you can't speak for yourself. Some people call it a living will. It provides guidance to the person you've appointed, like I said. The crux of the question, though there are other areas that we address, but the crux of the question in that document is, if you're ill with no hope of recovery, do you want the agent you've appointed to have the authority to withdraw or withhold life-sustaining measures? Doesn't mean they have to. It doesn't mean they're mandated to. It just means if they get to that point at the end of your life when it's clear that you're not going to get better and there's nothing further that can be done, do you want to be kept alive on the machine? I will say most people want their agent to have the option to remove or withdraw life-sustaining treatments under appropriate circumstances. That document also addresses if you want maximum pain relief, if you have specific wishes regarding organ donation, we often include it in that document. Again, if you have very specific wishes regarding funeral and related arrangements, we can mention it in that document. Address different religious principles that you might want to apply to your funeral and related arrangements. So that's an important part of that discussion when we're talking about the healthcare declaration. It also expires upon your death, and it's revocable during your life, as long as you have capacity. So what happens if you didn't put these documents in place and you become incapacitated during your life? We talked a little bit about what happens after you've passed away, what happens to your estate, but what happens if you don't have these simple, and they're simple documents, the power of attorney, they're more, more comprehensive is probably better, but they're not, you've seen them, they're not, it's not rocket science. It's kind of, you're putting someone in place and you're telling them what they can do. And there's not a ton of variation in them. Sometimes people have specific wishes or restrictions that they might like to place on the person they've appointed, but generally, because they're appointing somebody they trust to do what needs to be done, you want to give them the maximum flexibility without tying their hands. But if you become incapacitated during your life, technically nobody's supposed to be making decisions for you. If you're ill in the hospital and you can't speak for yourself, do they sometimes look to your spouse and your children? Maybe. What if there's a disagreement among your parents and your spouse? There's lots of things that can go wrong. So if you are in a situation where you're incapacitated and you cannot sign these documents and somebody needs the authority to be able to help you with your finances, your loved ones are put in a position where they have to file for guardianship of you, right. Which is an extensive and an expensive process that nobody wants to have to go through, because you're essentially asking a court, now you're inviting the court into your family, and you're asking them to declare your loved one incapacitated, unable to manage their person and their financial affairs. Nobody wants that. And especially if you've got people that don't agree as to who should be in charge. So now you're in a horrible situation in your family, and now your family's fighting about it, which is never good.
Right.
So that's, and it's easy to avoid. It's easy to avoid with some simple estate planning documents. So I think it's time well spent based on that. So we talked a little bit about trusts under wills, and I'm just going to go through this very quickly, because I want to be able to address the specific questions that you received. But you can also create trusts that are created under wills are called testamentary trusts. They essentially live in your will. They're not really trusts yet. They're waiting to become trusts. And when you pass away and that trust is going to be funded, then it becomes a trust. But some people will create trusts during their lifetime. There are different types of trusts. Those are called inter vivos trusts. There are different types of trusts. Revocable trusts are frequently used in place of a comprehensive will. A revocable living trust is a trust where the goal is to put your assets that are appropriate into the revocable living trust, so that when you pass away, you don't have to probate your will. Instead, everything's in the trust, and the trust does the job and says where the assets should go. Those are particularly popular in states where probate is difficult. And if you remember earlier, I said it's one of the things we actually do pretty well. So, there are certain instances where I will use them, but it's not my go-to tool. In New Jersey, in Florida, where it's very difficult to probate a will, everybody has a revocable living trust. It just is, it's the tool that is most commonly used there. There's really no benefit from a asset protection perspective. You have control over those assets, so the assets can be removed by you during your lifetime. So if somebody sues you, they can just as easily get to that trust as they can to your bank account. And also, because you have control over them, they're included in your taxable estate upon your passing. So there's no tax benefit to a revocable living trust. But I get the question a lot. People think they need a revocable living trust, and the answer is maybe you do, but not everybody does.
Which takes me to a question too, though, Naomi.
Yeah.
We have being that we're in the Northeast, a little cold, we have our snowbird, they go into Florida or
Yeah,
South. Can you just address that issue of primary residence and how that affects
sure.
whatever you're in?
So we have a lot of people that move to Florida for the reason that you indicate, Valencia. Domiciles is a little trickier than just spending half the year plus 1 day, but there are definite benefits to retirees that move to Florida, income tax benefits. When New Jersey had an estate tax, there were definitely estate tax benefits. Right now, we don't have an estate tax, but that could come back at any time, who knows? And so there are definite reasons that people change their domicile to Florida. Domicile really goes towards intent. This is where I intend to spend the majority of my time. I'm showing that intent by changing my license, changing my voter registration. My primary residence is there. I spend a sufficient amount of time there. I believe there's also there's some legal steps you can take to show your intent in Florida with a Florida licensed attorney, which I am not. But there are definitely steps to take if you're planning on treating Florida as your primary, as your domiciliary state.
And which would affect how your decisions are in terms
Correct.
of your state. Just to point that out to everyone.
I mean, correct.
A part of consideration with your estate is you have to consider where you're domiciled and how that will work with the state that your intent state.
That is correct. So frequently if we have clients that spend some time in Florida, but not a majority of the time, that's frequently a discussion that we have. Maybe 5-10 years from now, are you considering changing your domicile to Florida? Because maybe under those circumstances, and frequently people that spend time in both places might own real estate in both places. That's a good reason to have a revocable living trust. Because if you own real estate in multiple states, and you pass away, then you have to probate the estate in different states. So what we do is we try to get the real property into the trust so that it does not require a probate proceeding in those ancillary states. So it's another good reason to use a revocable living trust, but that doesn't apply to everyone.
Right.
Some people will do inter vivos irrevocable trusts if they're trying to do some tax planning or gift planning. It is a way to relinquish control of assets but still protect it in a trust, which is a trust is an agreement between the person that's creating the trust and the trustee that they've appointed to manage the trust. The trust dictates how assets can be distributed, how they should be invested, what the intent of the trust is, and there's all different, we could talk for a good hour on the different kinds of trusts that there are. But know that they exist and they are a powerful tool under the right circumstances, depending on what you're trying to accomplish in your estate planning. Also, it's particularly important if you, again, have a dependent with special needs that might require benefits. You can create a special trust that will allow you to put money into the trust for that person and not interrupt their benefits, which frequently can be really life-changing for a beneficiary receiving benefits. Okay, so my common estate planning mistakes in Valencia, I'm sure that you see these a lot. The biggest one is not planning at all. Putting it off, not wanting to deal with it, and then we end up in a situation where there's either an emergency and a guardianship action is needed, or you pass away and the estate is distributed pursuant to the intestacy laws, which really wasn't consistent with your intent. And it really breeds fighting among your family, or it can. So it's better to have your wishes known. I talk to people a lot. Talked to somebody today, actually, that she said, no, I want a simple will, but a simple will doesn't usually get the job done. A simple will really doesn't do much more than the intestacy statute. So, I think the goal should be to have a thoughtful will, one that really takes into account what you're trying to accomplish, what your concerns. Everybody has concerns about what's going to happen after they're gone. And, and I will say fair is not always equal. There's, lots of different things that need to be considered when you're deciding how your estate should be distributed and how it should be structured. So simple doesn't usually jive with that too well. Not planning for your financial needs. Again, this is big when you have a dependent with special needs. If you're the primary caretaker for that person, what happens? What happens when you're no longer here to take care of them? And how are we going to make sure there are sufficient assets available to take care of them? You know, so life insurance comes into that discussion, making sure that you're supporting your, you know, your survivors. If you have a taxable estate, how's that tax going to be paid? All different things when considering the financial aspect of your estate plan. We talked about it very early on. It's imperative that you coordinate your estate planning goals with your beneficiary designations. Again, it can create the most creative will, and if nothing is passing through it, it doesn't mean anything. So it's a huge part. It's a step. And not considering estate taxes, because that's, you know, you have to be flexible in that. Even if you don't have an estate tax right now, nobody knows what the tax regime is going to be when you pass away. So, you know, the goal is to make it as flexible as possible to try to anticipate the what ifs. So common misconceptions. If I become incapacitated, my husband will take care of me. My children will take care of me. Maybe. But maybe they'll run into roadblocks that could have been avoided if you had the right documents in place. I get this one a lot. If I become incapacitated, my executor under my will take care of everything for me. But that will only matters once you've passed away. So anybody, you know, I don't generally get a call that says, we need to do our estate planning. I get a call that says, I need a will. And then we talk about the other documents that are important, and that conversation evolves. But if you just have a will and you become incapacitated during your life, you have no protection. So that's something to think about. I don't need estate planning. Oh, go ahead, Valencia.
I was also thinking about the fact that a lot of persons think incapacitation means when you're physically, you know, in a hospital bed or stuff.
Yep.
But
no, definitely, it's very frequently mental incapacity.
Right, the cognitive aspect, the Alzheimer's, the dementia, as it is. And I mean, I need to speak to you actually, somebody too. It just came to my attention. I have a 64-year-old who has just been diagnosed with early onset Alzheimer's. And I'm like, I need you in front of an estate attorney like now.
Yeah.
Because this is something that, you know, like you would read in a document.
Right.
I'm in a good state of mind to make my decision. So people need to start thinking about that early. Will I be, you know, the cognitive aspect too is very important. If you're not here.
Correct. And just because somebody has been diagnosed doesn't mean that they're incapable of then putting a plan in place. And frankly, their decisions might be a little different than if, you know, they put the planning in place years before. So even if you have a plan in place, it's a really important time to look at those documents, because now your needs are different. Now the future looks different. So if there are ways to further protect yourself, your family, and your loved ones, it's better to do it while you can still make those decisions.
That's right.
I don't want my family to go through probate. It's not a big deal in New Jersey. I mean, New York's a little bit more complicated, but it's not that big of a deal. I don't have enough money to need an estate plan. Well, again, my experience has been no matter how much or little money you have very specific wishes as to how you want things to be handled. And regardless of how much money you have, if you become incapacitated, you become incapacitated. So those challenges don't know how much money is in your checkbook. So it's really important to address it regardless of what you have to pass on your death. So my life insurance is not included in my taxable estate. This comes up all the time. And one of the big selling points with life insurance is that it is income tax free to the beneficiary. But what we talked earlier, remember about the probate versus the non-probate assets, and that really just dictates how the asset is transferred. But even if all of your assets pass by beneficiary designation, when determining whether you have a taxable estate, the numbers are thrown into the pot. So whether or not you have life insurance that passes outside of your estate, you still have to consider it. And a lot of people are worth a lot more money dead than they are alive. So you have to really think about whether or not you have an estate tax issue. And again, right now, the federal exemption is very high. You know, you can give away $11.58 million without hitting an estate tax federally. And currently, New Jersey has no estate tax, but that's fairly new. And, you know, as far as I'm concerned, always on the table to come back. You never know. And we know that the federal estate tax exemption, regardless of what happens in the White House, is scheduled to go back down to $5 million indexed for inflation. And, you know, with real estate in New Jersey and a couple of life insurance policies, it's not hard to hit that number. So it's something to think about and something you should be considering, because there are ways to deal with it. And I actually think I'm going to stop it here, because the rest of it is the elder law piece, and that brings me kind of into the charitable giving part of it. Because, you know, some people are just charitably inclined, and they want to incorporate organizations and religious organizations that are important to them and remember them in their wills. But there is also, aside from the really good reason to support charitable organizations, there can also be income and estate tax planning benefits to giving to organizations that you support that are charitable in nature. You know, frequently when we're thinking about our estates and taxes, we're thinking about estate taxes, and giving during life versus giving on your death. But equally important are income tax considerations. So if you have assets that have a very low basis, what you invested in that asset, and the asset has grown, and you have you're in a high income tax bracket, there are lots of reasons to do charitable planning both during your life and upon your death. So it's an important discussion to have, especially if you were charitably inclined, because there are a lot of benefits to it as well. There's options available with retirement assets. So if you don't need that required minimum distribution and you've reached a certain age, you can make direct contributions to a charitable organization and you know, do a good thing, and also receive an income tax deduction for it. If you can benefit charities by making them beneficiaries of certain assets. Perhaps you might want to consider it on an IRA that's income tax deferred, and give the other assets to a beneficiary that won't have to pay income taxes on it, because a charitable organization, if you leave them a qualified asset, will not have to pay income taxes on it. And then there's different kinds of trusts that allow you to kind of have the best of both worlds, where you can make an individual a beneficiary. It's called a charitable remainder trust. So an individual can be the beneficiary, but the charity is the ultimate beneficiary. And there are definitely some income, and depending on when you establish it, income and estate tax benefits to that. Yeah, it's an important part of many people's estate plans.
Right.
And the perfect time to think about it too.
Right. I know you weren't going to touch much on elder care. Can I just ask you to do 1 minute on it in terms of long-term care is something that we don't necessarily speak of or think about, but that's also very important. So could you just do like a quick minute on?
Sure. So elder care actually is, there's a lot of overlap between elder law and trust and estates law. Older people need estate planning documents. Older people pass away, they have probate. If you don't have documents, we have guardianship proceedings. So all of those things we've already discussed apply. The one really unique component of elder law is planning for long-term care. And what are your options when you're planning for long-term care? There's always a common misconception that Medicare will take care of long-term care, but Medicare doesn't. It's health insurance essentially that you qualify for when you reach a certain age. So the options generally to fund long-term care is long-term care insurance. So if you have put that in place and it hasn't become too cost prohibitive, that is a great way to pay for long-term care. You can private pay, but in the North Jersey, $12,000 to $15,000 a month, it's a lot of money. And then once you run out of assets, there is Medicaid that as it stands today, will currently fund long-term care costs in a facility, 24/7 care versus other options in an assisted living facility, which is a slightly different program, but it's available under certain circumstances. And there's community Medicaid if you only need some help in the community. Then, but it's never going to be 24/7 care. It's more like 24 hours total a week where you can get some help in the community. And essentially with Medicaid, there are two arms that you have to qualify for. Physically, you need to need the services that you're being provided, and financially, you need to qualify. So financial qualification looks a little bit different if you're a single person versus a married couple. It's if you are single and you need Medicaid, you can't have more than $2,000 in your name, which goes back to the discussion we had about dependents with special needs, because frequently children with special needs, once they age out of the school district and they turn 21 and they're no longer being educated in the school district, there are other programs out there where they can continue developing vocationally and educationally. But frequently you need Medicaid to be able to qualify for them, which is an important thing to think about. Because $2,000, I mean, you've got a grandparent that started an UGMA account for a kid, and now they're 18 years old and they've got money in your name, and now you have a problem. So that's something to think about. When you have a married couple, it's a little more complicated. Essentially, they take a snapshot of the assets. It doesn't matter whose name it is, husband, wife, joint, they don't care. They're looking at you as a whole. So they take a snapshot of the assets when you needed care. So let's say the day you went into the nursing home, maybe you had $100,000. All in combined, they say you have to spend down half, 50% of those assets. But if you started with 500,000 and you spent down to 250,000, that's a no-go, because there's a ceiling and a floor. If you have to spend, the ceiling is about 126,000. It fluctuates every year, and the floor is about 26 or 27,000. So if you started with 30, they're not going to make you spend down lower than the floor. And if you started with $1 million, and you say, you got to go down to the 126.
Right.
And then there's certain assets that are exempt when you have a spouse in the community. When one spouse is ill and the other spouse is in the community, they understand the spouse has to live. They need their house, they need a car, but there are ways, to plan. Right. For that too, and to do it in a smart and a comprehensive way.
Right.
So
I'm glad you touched on it. We won't spend a long time on it, but it's so important to have that conversation about long-term care. There are a lot of misconceptions out there about it. And we do know that long-term care insurance typically is a little expensive.
It is.
But there are ways to work around that. But again, as responsible stewards of our own personal lives and our family's legacy, this is where we must have conversations with the persons who are equipped to guide you along the way. There's some options out there.
There's definitely options. Definitely
have that conversation, because you may think that you are okay, but you just need a good opportunity to not have a good medical situation, and that money that you think you have is basically worth nothing in a short period of time.
Right.
The average person maybe has about 2 years, 3 years after entering nursing home, but if you are spending $15,000 a month, that adds up pretty quickly.
Especially if you have a spouse that's that needs to continue to live in the community.
Exactly.
It's huge. And also you want to think about, it's very difficult for me to help you if you call me and you tell me that we are now triaging and my father is going into a nursing home, and what do we do? To the extent the family can wrap their head around having that conversation earlier, it's huge. It's huge. Definitely. And, I'm sure you see there's a ton of products out there now that aren't straight long-term care insurance policies that really you can be very creative and very flexible. And it's definitely worth having the discussions. And even if at the end of the day you decide, it's not for me, at least you've made an informed decision.
Right. And
which
like anything in
huge.
finance, like the earlier you begin, the better it is for you. I mean, if you're
Right.
going to do a long-term care at age 60, that's kind of late. But if you started it a little
Yeah,
earlier, it's more manageable and you're
correct.
covered
Cost-wise, for sure.
for sure.
There's a sweet
Um,
spot.
yeah. But Naomi, you have just been a wealth of information there. I don't think we could ask for more in terms of
Well,
what you
thank
have
you.
presented tonight. Um, we know estate planning is a difficult conversation because death and dying is not things that people like to talk about. But we're not speaking about estate planning tonight from a concept of death and dying only. We're really talking about how do you protect yourself and how
Correct.
do you protect your loved ones. We have to take the responsibility to have these conversations early and have them with the right people. Make sure that you have your attorney, your accountant for those who need, an accountant. Make sure you have your advisor, and quite importantly, have your family conversation. A lot of times
100%.
we don't have that family conversation, and we need to. We need to be on the same having the same outlook as we go forward. So.
Correct. I mean, if you look at it as just being proactive in ensuring, that the things that you can address that you do. I mean, the truth of the matter is, at the end of the day, whether we do our planning or not, eventually we're going to pass away.
Exactly.
And also, there's always the chance of disability. So why not participate in it when it's not imminent?
Right.
It's a different conversation than when you are in an emergency situation.
Right.
I can tell you from a practitioner standpoint, it's a lot easier to have the conversation with the family when they're talking about what ifs versus when they're literally about to die. So,
so awesome.
Yeah, it's night and day, and really, and some families are kind of, they don't want to have the conversation as a whole, but honestly, to the extent that you can come together and have that conversation so that people understand why you've done what you've done, it will help things so much more later when you're not here to explain why you did what you did.
Right.
So
I think this has been a really awesome
thank you, Donna.
Presentation. And Sister Valencia, were you going to say something before I?
Well, I was going to wrap up and turn it back over to you, Donna, because, I just wanted to remind people about some choice words. We heard a lot of tax coming up. I don't know who wants to pay extra taxes if they don't need to. So let's consider that. Let's consider the fact that ultimately, as Christians too, we do know that one of the first things we got was choice. And we have a choice to the kind of outcomes that we want. So let's make that choice, do it well. Love is an action word, so let's show our love to ourselves and our families by planning. And it was my pleasure to have Naomi, and it was my pleasure to just join the Forever Young team just to help facilitate this session. So Donna, it's all yours.
And I just want to say this has been really, really out of the world experience in terms of information that has been shared with us. And I'm praying that our viewing audience have really got something out of it, if not all, but something that they can apply right away. Naomi, again, we thank you so much. Sister Valencia, we thank you so much. But just before we close up, I know we're beyond our hour right now, but can you share how our audience can get in touch with you?
Sure, and I'm happy to provide to you. Valencia has the presentation, so please feel free to share with whomever it is helpful to. But my contact information is listed on Pashman Stein's website, and anybody can feel free to reach out to me if they have any specific questions. My telephone number is 201-639-2011. That's my direct dial. And my email address is ncollier, COLLIER, @pashmanstein.com. And I welcome, if I can help be a tool to either one of you, I'm happy to do that.
All right.
Thank you
So
so much. And we do look forward to our next month. We'll be back again, continuing our strategic goal. Our time has far spent. And so we're going to say goodbye, stay well, be safe. Thank you so much again, Sister Valencia and Naomi.
thank you for having me. It was a pleasure seeing you both.
Sure. Bye-bye.
Bye-bye.
Bye-bye.